Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. A lot of times we talk about modifying custody. I want to spend a moment or two talking about what are the requirements for modifying an existing custody order. And what I mean by that is father and mother have a child and there's a custody order already in place. For whatever reason, somebody wants to change it. I don't know, maybe it doesn't work anymore because of the work schedule. Maybe the child is now going into a school, or maybe going from grade school to middle school to high school, and now, therefore, it just doesn't work. Maybe the child's friends are more important than his parents, and therefore the child's not cooperating. Whatever the reason may be, we want to modify it. How do we do it? What are the requirements for modifying it? I'll tell you generally. The court will not modify its orders without some compelling reason to do so. The court has to have a reason to first even revisit the custody order. Before the court determines, think of it as a two-step process. Before the court determines whether to modify, first it has to be convinced that there's a compelling reason, a change in circumstance that supports even looking at it again. And the change in circumstance might be the things that we discussed. Work schedule change, this kind of, and so when the court gets a motion to change, the first thing it looks at, do we have a change in circumstance that is significant enough that we should even look at this? So number one, you have to convince the court that the circumstances have changed, and then number two, if there has been, the court will set up a hearing and determine, is that change such that we should modify, and if we should modify it, what should the modification be? So you're going to have to look at those things. So once you convince the court, yes, there's a reason to look at it, the court may nonetheless still feel, yes, we're looking at it, but no, we're not agreeing to change it, or yes, we're looking at it, and we've got to change it. If so, to what? And then the court will hear from the parties what they want, why it needs to be changed, what the schedule needs to be, and then the court will make a determination going forward, should we change it, and what are the circumstances. Remember, the court tries to come up with orders that promote a cessation of litigation. The court is not trying to promote a continuance of litigation, okay? So when the court gave its first order of custody, it was at least engaging in the fiction, perhaps, but it was hoping against all hope that it'd never see these parties again. That the custody would work out fine, and if there were changes, they would do it just internally, and the court's not involved. Why? Because the judge doesn't want to decide how you should run your life. And the court doesn't want to say what kind of parent you're going to be, and when you'll see your kid, and you'll see him Monday, Wednesday, Friday, and Tuesday, Thursday. The court doesn't want to do that. If you force the court to do it, it will. So the court puts up an order which it thinks will work. Therefore, if you want that court to change that, you're going to have to show a strong reason why it just won't work anymore. And that's why the court puts these hurdles in front of you. Show that there's a change of circumstance. If there is, show that therefore there should be a change and what that change should be. Now, if you have any questions about your particular custody case, reach out and we'll be glad to help you out.